Well, good evening, everybody. I'm Paul Ozell. I'm Principal of Royal Holloway, University of London. I'm delighted to welcome you all to this Royal Holloway event, our Magna Carta lecture. We've got a large audience drawn from around the UK and internationally, and it would be helpful if you go on to mute. So this is the fifth of our second series of Magna Carta lectures, and it was made possible by the generosity of two donors, the Magna Carta Trust and their 800th anniversary commemoration committee, and the charity Runnymede Magna Carta Legacy. Our thanks to them and their representatives who are joining us today. Very, very grateful for your support. This new second series of lectures allows Royal Holloway to continue to hold an annual Magna Carta lecture until 2025, which will coincide with the 800th anniversary of when King Henry III issued what was to become the final and definitive version of Magna Carta. Our Magna Carta lectures have covered almost every aspect of the themes raised by the history of Magna Carta, themes of rights and liberties, of granting of fair justice, and of the freedom of the individual under the law. Today we welcome the Right Honourable the Baroness Hale of Richmond to deliver the 2021 Magna Carta lecture. Lady Hale read law at Girton College, Cambridge, and began her career as a lecturer specialising in family and social welfare law at the University of Manchester. She was called to the bar by Gray's Inn in 1969. She worked part-time as a barrister while continuing to teach law at Manchester, and she was appointed a professor in 1986 and appointed Queen's Counsel in 1989. In 1984, she was the first woman to be appointed to the Law Commission, contributing to the passage of important legislation, including the Children's Act 1989, the Family Law Act 1996, and the Mental Capacity Act 2005. In 1994, she was appointed a judge of the Family Division of the High Court, the first High Court judge to have had a career as an academic rather than as a practicing barrister. She was promoted to the Court of Appeal of England and Wales in 1999 to become only the second woman to hold that position. And in 2004, she was made the first female law lord and created a life peer as Baroness Hale of Richmond. Lady Hale became a Justice of the Supreme Court of the United Kingdom when it was established in 2009, and she rose to the position of President of the Supreme Court in 2017, one of the highest judicial appointments in the United Kingdom. Whilst a distinguished academic and holding high office in the law, Lady Hale is perhaps best known in the public consciousness, along with her iconic spider brooch, for having delivered the Supreme Court's 2019 ruling that the government's suspension or prorogation of Parliament was unlawful, the topic that she will speak to us about today. After the lecture, Professor Matthew Humphreys, head of the School of Law and Social Sciences, will chair a question and answer session, and he'll give you a bit more information about how you can submit your questions at the end of the lecture. But first, it's my great pleasure to invite Lady Hale to give the 2021 Magna Carta lecture entitled Prorogation. Thank you.
Thank you very much indeed. It's great to be with you all. I'm sorry that I can't be at Royal Holloway itself, and I'm speaking to you from my flat in Westminster. Something is better than nothing. Anyway, here goes. Wednesday, the 11th of September 2019, was a memorable day. I was attending the annual Global Constitutionalism Seminar at Yale University, a stimulating encounter between top judges from all over the world and academic constitutional scholars, all devoted to exploring and promoting the cause of constitutionalism. The idea that government can and should be legally limited in its powers, and that its authority or legitimacy depends on observing those limitations. In the course of the day, we learned that the inner house of the Court of Session in Scotland, headed by Scotland's top judge, had held that the Prime Minister's advice to Her Majesty that Parliament should be prorogued was unlawful, because its motive was to stymie the proper functioning of Parliament, and that the prorogation was accordingly null and void. But we also learned that a divisional court of the High Court of England and Wales, headed by the top judge of England and Wales, had held that the issue was non-justiciable. The case obviously had to come to the Supreme Court. There is only one UK Parliament. Either it had, or it had not, been validly prorogued. Only we could choose between the two. Equally obviously, we had to do so quickly. If the Scots were right, Parliament should resume its role as soon as possible. Otherwise, the unlawful purpose would have been achieved. We decided for a second time to convene a panel of 11 justices, the maximum number of serving justices who are allowed to sit, because the Constitutional Reform Act 2005 requires us to sit an uneven number. We'd done this with the first case brought by Mrs. Miller, because the feelings in the media and the public were running so high. We didn't want it to be said that the composition of the court had made a difference to the result. The justices rallied round, and those who could do so changed their travel plans in order to be there. The justice whose plans were the most difficult to disrupt had to be left out. The hearing was fixed for the following week, Tuesday to Thursday, 17th to 19th September. The parties were given impossibly tight deadlines to file their written submissions and the required bundles of documents. Interventions were allowed from the Lord Advocate representing the Scottish Government, the Counsel General for Wales, and a litigant from Northern Ireland. From Sir John Major, because he could give unchallenged evidence about the normal process and timetable for prorogation, and in writing from Baroness Chakrabarti and the Public Law Project. The practical arrangements which the court had made for the first case brought by Mrs. Miller were set in motion once again, moving the furniture to make room for 11 of us on the bench, making plans for who should sit where in the main courtroom, arranging ticketing for people who wanted to attend, broadcasting on television as well as over the internet, and so on and so on. So the stage was set. But what was the case all about? Why all the fuss? After the first case brought by Mrs. Miller, Prime Minister Theresa May, with the approval of Parliament, had given notice on the 29th of March 2017 to the European Union that the UK intended to withdraw. This would automatically take effect 2 years later, on 29th March 2019. Parliament then passed the European Union Withdrawal Act 2018. Among many other things, this required Parliament's approval for any withdrawal agreement negotiated by the government. Mrs. May tried 3 times to get that approval for the deal which she had negotiated, and failed 3 times. The EU agreed to extend the deadline until the 31st of October 2019. Boris Johnson replaced Mrs. May as Prime Minister in July. He had made it clear on many occasions that he believed that in order to achieve an acceptable deal, there had to be a credible threat that the UK would leave without any deal. But a majority of the House of Commons was firmly opposed to a no-deal exit. Parliament was due to return from its summer recess on 3rd September 2019. However, on the 27th or the 28th of August, the Prime Minister advised the Queen that Parliament should be prorogued from a date between the 9th and 12th of September until the 14th of October. In other words, for a possible 5 out of the 8 weeks between the 3rd of September and the 31st of October. The Queen duly made an order in Council to that effect. Parliament was duly prorogued by Lords Commissioners reading out the Queen's Commission at the close of business on the 9th of September. But in the meantime, in the few days between the 3rd and the 9th, Parliament had taken control of its business and rushed through the European Union Withdrawal No. 2 Act 2019. This required the Prime Minister to seek an extension to the exit date unless by then Parliament either approved a deal or approved exiting without one. There were 4 issues for the court. First, was the lawfulness of the Prime Minister's advice to the Queen justiciable? Second, if it was, by what standard was it to be judged? Third, by that standard, was it lawful? Fourth, if it was not, what remedy should the court grant? We often have to decide new and difficult points of law in the Supreme Court, but we are not making it up as we go along. The essential building blocks for our decisions are sitting there in our history. That is why the library is at the centre of the Supreme Court building. So how far back should I go? This is, after all, the Magna Carta lecture. So let us track back to Magna Carta itself, the document which many associate with the birth of English constitutionalism, although that is highly debatable. In the original Magna Carta of 1215, the king conceded 3 essential principles. First, the one that everybody knows and is still on the statute book, that no free man should be punished except by the lawful judgment of his peers or the law of the land. And to no one would justice be denied, sold, or delayed. Second, just as important, that there will be no new taxes without the consent of what was soon to be known as the Parliament. And third, perhaps the most important of all, that the king and his officials were to abide by the law. We will not appoint justices, constables, sheriffs, or bailiffs, except from such as know the law of the kingdom and are willing to keep it well. Fast forward to the 17th century, when the debate about whether the king was indeed subject to or above the law really hotted up. Enter Sir Edward Coke, who resurrected Magna Carta and gave it the almost mystical status which it enjoys today on both sides of the Atlantic. As Chief Justice of Common Pleas, Coke was also responsible for the case of Prohibition's Del Roy in 1607, which held that the king could not usurp the functions of the courts and decide cases as he pleased, and even more significantly, for the case of proclamations in 1610. The question was whether the king could, by proclamation, prohibit new buildings in and around London, or the making of starch from wheat, on pain of prosecution. Predictably, Coke's answer was that the king could not create any offence by his prohibition or proclamation which was not an offence before. In the same term, by the Chief Justices of all the common law courts, Common Pleas, King's Bench, and Exchequer, it was resolved that the king hath no prerogative but that which the law of the land allows him. That does, of course, beg the question as to who makes the laws, but that was resolved in the Glorious Revolution of 1688, when William and Mary accepted the throne on the express basis that only the king in Parliament could change or make the laws. It also begs the question of who is to judge what the law of the land allows him. But there has never been any real doubt that the courts are the judges of the existence and extent of prerogative powers. Consider the landmark cases of Entick and Carrington in 1765, holding that the Secretary of State could not issue search warrants without the authority of Parliament or the common law, or Attorney General against De Quisa's Royal Hotel in 1920, holding that the prerogative could not be used to evade a statutory prohibition on requisitioning property without compensation. That case is, of course, now more famous, the exchange between Lord Panic QC and me in the first Mrs. Miller case about how to pronounce De Keyser. There was a debate about whether it was De Keyser or De Keyser, but I am convinced that it's De Keyser, because that's how the English would pronounce a Dutch name, wouldn't they? So there we are. It led to the first of the set of T-shirts associated with the Miller cases. Fast forward from De Keyser to another building block, the Council of the Civil Service Unions against the Minister for the Civil Service. In 1983, the minister summarily banned the civil servants working at GCHQ from joining trade unions. The power to give directions to civil servants emanated from the prerogative. The civil service unions argued that it was unlawful to do this without consultation. The minister argued that the exercise of prerogative powers was not amenable to judicial review. The House of Lords held that it was. Lord Scarman pointed out that in Cook's time and thereafter, judicial review of the exercise of prerogative power was limited to inquiring whether a particular power existed, and if it did, into its extent, citing De Keyser for that. But, their lordships held, time had moved on, and even the exercise of a prerogative power might be subject to judicial review, unless its subject matter made it inherently non-justiciable. Lord Roskill gave as examples the making of treaties, the defence of the realm, the prerogative of mercy, the grant of honours, the dissolution of Parliament, and the appointment of ministers. Not all these exclusions have survived, and he did not include the prorogation as opposed to the dissolution of Parliament. But obviously, the list provoked much debate in our court. Fast forward again to another building block, the case of R against Chater in 2010. In May 2009, the Daily Telegraph had the scoop of the year. It bought the unexpurgated records of the expenses claims made by members of Parliament and began publishing a series of articles revealing them. These showed not only some of the outlandish things for which members had claimed, and that some of the claims were not within the rules, but also that some had made false claims for expenses that they had not in fact incurred, which is a criminal offence. The Director of Public Prosecutions, Sir Keir Starmer, decided to prosecute. The MPs argued that their claims were covered by parliamentary privilege. Article 9 of the Bill of Rights of 1689 declares that freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. So were the expenses claims made to an office in Parliament, in accordance with rules laid down by Parliament, proceedings in Parliament. We pointed out that it had been clear since the case of Stockdale and Hansard in 1839 that the courts were the judges of the existence and extent of parliamentary privilege. It didn't extend to exempt fraudulent expenses claims from prosecution. Proceedings in Parliament are what MPs do when they go about the core business of the House, taking part in debates, questions, committees, votes. Not anything and everything that MPs may do when they're in the Palace of Westminster. So these were the building blocks for us to decide the 4 questions raised in the great debate between Scotland and England. By close of play, on the second day of the hearing, we had heard from both parties in each case. Lord Pannick for Mrs. Miller, appealing against the English decision. Lord Keane, the Advocate General for Scotland, appealing against the Scottish decision. Sir James Eadie, responding to Mrs. Miller's appeal, and Aidan O'Neill, responding to the Advocate General's appeal. So we knew there are arguments on the 4 questions. I asked that each of the justices hearing the case circulate a short paper giving their answers to those questions at 9 a.m. on the following day. From this, it became clear that we would hold that the question was justiciable, that a manageable standard by which to judge the Prime Minister's advice could be achieved, and that it was likely that this advice would fail that standard. But if so, little attention had yet been paid to what the appropriate remedy should be. So we asked Lord Pannick and Lord Keane to focus on this in their replies. We spent the morning of the final day listening to the interveners, mostly very helpful, apart from counsel for the litigant from Northern Ireland, who had to be reminded more than once that we were not there to debate whether Brexit could be reconciled with the Good Friday Agreement. We spent the afternoon mainly debating the issue of remedies with the parties. As respondent in the Scottish case, Aidan O'Neill would have dearly loved to have got to his feet, but he had no right of reply. However, he did put in some very helpful written submissions, which we considered alongside those hurriedly compiled by the other parties. Astute observers, including Clive Coleman of the BBC, will have realised by then how we were likely to decide the first three questions. And if any of you listened to his contribution to the Today programme on the morning before judgment was delivered, you will realise that he got it virtually spot on. However, I do think that our answer to the fourth question may have taken some people by surprise. What also took some of them by surprise was the speed with which we were prepared to give judgment. But we were already 10 days into the prorogation, so time was of the essence. We determined to give judgment the following Tuesday, 24th September. Lord Reid, the Deputy President, and I decided how the issues would be shared between us. We thought, read, and wrote furiously over the weekend, exchanging drafts as we went. By Sunday morning, we had a draft which we could share with the other justices. Throughout the day, we revised it in the light of their very helpful comments, and by Monday morning, we had an agreed draft which we could send to the court to be processed, ready for handing down the next day. I spent the Monday working on the summary to be delivered in court on the Tuesday morning. Our answers to the four questions were quite simple. As to justiciability, all the parties agreed that the court could decide upon the existence and extent of a prerogative power. It was only when it came to the exercise of a power within its lawful limits that questions of justiciability arose, as in Counsel for the Civil Service Union showed. We concluded that the case was about the extent of the power to prorogue. That power could not be unlimited. This followed from two fundamental constitutional principles. One was parliamentary sovereignty, that the laws passed by Parliament are the supreme form of law. Not only do the courts recognise that, they have also protected parliamentary sovereignty from the threats posed by the use of prerogative powers. So how should the limit on the power to prorogue be defined so as to be compatible with parliamentary sovereignty? The other principle was parliamentary accountability. The government is accountable to Parliament for their policies and actions. The longer Parliament is prorogued, the greater the risk that responsible government may be replaced by unaccountable government, the antithesis of democracy. So what is the legal limit which is compatible with this principle? We concluded that advising the monarch to prorogue Parliament would be unlawful if the prorogation had the effect of frustrating or preventing, without reasonable justification, the ability of Parliament to carry out its constitutional functions as a legislature and as the body responsible for supervising the government. If this prorogation did have that effect, without reasonable justification, then we didn't have to consider whether the alternative case, that the Prime Minister's motive was to stymie Parliament from legislating to prevent a no-deal exit, was justiciable. It was not difficult to conclude that the prorogation did have that effect, and more significantly, that no reasonable justification had been advanced for it. When judicial review proceedings are brought, the Treasury Solicitor writes to the government departments involved, asking for them to disclose any documents relevant to the claim. The government has a duty of candour when the legality of its actions is challenged. That request yielded only one document from number 10, which provided any sort of explanation. A memorandum from Nicky da Costa, Director of Legislative Affairs, to the Prime Minister. This focused on the reasons for beginning a new session with the Queen's speech on the 14th of October, a date which had long been in the Queen's diary, but scarcely at all on why it was necessary to shut down Parliament for 5 weeks before that, rather than the usual 4 or 5 days it takes to prepare the Queen's speech. The memo pointed out that if Parliament took the usual time off for the party conferences, very few sitting days would in fact be lost. But it didn't consider whether Parliament might instead want to spend its time scrutinising the government's proposals and legislating for the fundamental change which was due to take place on the 31st of October. The Prime Minister agreed. As we now know, he described the September session as a rigmarole devised by that girly swot, David Cameron, to show the public that MPs were earning their crust. So he didn't see anything particularly shocking about it. Interesting that he used the word shocking, indicating perhaps that he knew it was unusual. No reasonable justification having been advanced, the advice was unlawful. What were the consequences? The Scottish court had taken their finding to its logical conclusion and held that the prorogation itself was null and void. The government argued that we couldn't do that because, unlike the advice, it was a proceeding in Parliament, which couldn't be impugned or questioned in any court. Relying on Chaytor, we held that it was not a proceeding in Parliament. Although the actual prorogation took place in the House of Lords, in the presence of members of both houses, it was not something which Parliament had debated or decided. It had been imposed upon them from outside. They had no choice in the matter. We were not, therefore, precluded from considering its validity. The advice to Her Majesty was unlawful and thus of no effect. The order in council to which it led, being founded on the unlawful advice, was also null and of no effect. It was as if the commissioners who pronounced the prorogation had walked into Parliament with a blank sheet of paper. It followed that Parliament had not, in fact, been prorogued. This meant that it was for Parliament to decide what to do next. There was nothing the government needed to do. The Speaker of the House of Commons and the Lord Speaker could take immediate steps to enable each House to meet as soon as possible. Parliament returned the following day and reasserted its will amidst noisy scenes. Exit day was postponed until the 31st of December. Parliament was prorogued again, but this time for only a few days before the Queen's speech, which had been arranged for the 14th of October. We went along in our finery to hear it, knowing full well that there was likely to be a general election and another Queen's speech before the year was out. And so it turned out to be. I felt very sorry for Her Majesty. She could so easily have been spared it all if it had been clear from the outset that that was the plan. The general election resulted in a landslide victory for the government. A deal was done, and on the 31st of December, we duly exited the European Union. Getting on for 2 years later, what are my reflections? Well, I have 5. Firstly, what if there had been no case? The legal position would have been the same. But without a court to decide what it was, no one would have been any the wiser, and the prorogation would have continued. We do need people who are prepared to bring cases when fundamental constitutional principles are involved. Of course, that is not usually their main motivation. They have something else they want to achieve. Mr. Stockdale, that well-known pornographer, wanted damages for being accused in Parliament of publishing an obscene book. In Bowles and the Bank of England, another landmark constitutional case, Mr. Bowles wanted the government to prioritise financial business in Parliament, so that the Finance Act was passed before the tax was levied. In Attorney General against Wilkes United Dairies, the dairy wanted not to have to pay a levy on every gallon of milk it sold. I don't know precisely what Mrs. Miller and Miss Cherry wanted to achieve, but at the very least it is likely to have been to avoid a no-deal Brexit. The fact that people bring these cases to achieve a political objective does not mean that they should not be brought or that the court should not decide them according to law. Courts are not deciding whether the political objective should be achieved. They are deciding what the law requires. Secondly, what if we had had better evidence? What if the Prime Minister had filed an affidavit saying that he was determined to maintain the realistic threat of exiting without a deal, while Parliament was determined to prevent him, and so he deemed it necessary to suspend Parliament's activities in the run-up to exit day? This is the really difficult question. We stressed that we did not have to decide upon the Prime Minister's motivation. We were only concerned with the effect of what he had done. But according to the standard we set, there might have been a reasonable justification for taking such a drastic and undemocratic step. Could we have decided, had this indeed been what the Prime Minister wanted to do, that this was a reasonable justification? Could the desire to avoid parliamentary scrutiny ever be a reasonable justification? The Scots did not think so. But would even addressing this question have taken us into non-justiciable territory? Thirdly, would it have been better if we had not been unanimous? Lord Brown of Eton-under-Hayward, a retired Supreme Court Justice, has publicly expressed the view that the decision would have had more power if we had not been unanimous. People could then have read a judgment or judgments reaching a different conclusion. They would have been able to see why the majority had rejected those arguments. This does not emerge so clearly from a unanimous judgment. I acknowledge that because of the time pressure we were under, our judgment does not rehearse at length the arguments which we had heard from the government. But it is quite clear what those arguments were. My own view is that the unanimous judgment of 11 top-rate, hard-working and conscientious lawyers, not perhaps as diverse as I would like, but with very different expertise and approaches to law, has much more power than a split decision would have had. Fourthly, what should be the role of public opinion? We tried hard to explain that we were not deciding whether the UK should leave the European Union, or even whether the UK should be prepared to leave without a deal if none was forthcoming. But that is not how large numbers of the public saw it. And I gather that the public's approval or disapproval of our decision was strongly correlated with their views on Brexit. But I'm not sure that the correlation was complete. A great many people signalled their approval by buying the T-shirt with the sparkly spider, like Amber Rudd and her daughter, or by wearing spider brooches or pins. like the pikemen who escorted the judges to the legal service in York Minster on the 13th of October. I have no idea what their views on Brexit were. I know it sounds pompous, but our own views on Brexit were completely irrelevant to the legal issues we had to decide. I didn't ask my colleagues what their views were. I do not know what, if any, political parties they support. And the views of the public were equally irrelevant. I'm not sure that they always are. The law has to move with the times and keep up with how public opinion is moving. Attitudes to homosexuality are a case in point. But in this case, public opinion was all over the shop. And in any event, a question of high constitutional principle cannot be decided in accordance with the public's views on something completely different. So finally, was it all worthwhile? It might be said that, because Parliament was soon dissolved, a general election called in which the government secured a large majority, an exit was done on the 31st of December rather than the 31st of October, it was all a complete waste of time. I cannot agree. Stockdale and Hansard was swiftly followed by the Parliamentary Papers Act 1814. Bowles and the Bank of England was swiftly followed by the Provisional Collection of Taxes Act 1914. The first Mrs. Miller case, the Queen on the application of Miller against the Secretary of State for exiting the European Union, was swiftly followed by the European Union Notification of Withdrawal Act 2017. But all three of those cases established important constitutional principles which would be followed by future generations. The Miller-Cherry case reaffirms the principle, which dates back at least as far as Magna Carta, that no government is above the law. Otherwise is tyranny. Thank you.
Lady Hale, thank you very much for a very thought-provoking, very interesting speech. You took us straight back to some very contentious times, brought them back to life, and then made some really interesting observations since. Now we have about 15 to 20 minutes available for some questions. Lady has very kindly agreed to answer some questions. Can I propose that people put the question in the chat? I will check them and try and manage the number that we can then put to Lady Hale. While people are thinking about that, perhaps I could start us off with a question that we got from some of the students and stuff a bit in advance. I mean, you mentioned, actually, I've adapted a bit, you mentioned the building blocks in the decision. You also mentioned constitutional principles. I just wonder, in your reflections, if you have any thoughts about whether a written constitution, some sort of codification of all of that would actually have helped the court, or would it have disadvantaged the court?
Well, thank you for that question. I've got two reflections on the matter. Number one is that constitutions tend to say there will be a legislature, a parliament, which makes the laws. There will be a judiciary, a legal system, which interprets and applies and enforces the laws. And there will be a government which runs the country. And it may, if it's a Commonwealth constitution, it may very well say that the government can exercise the powers previously exercised by virtue of the royal prerogative. Those constitutions never tell you exactly what the royal prerogative involves. In other words, they do not answer the really difficult questions. They wouldn't have answered the question raised by the Mrs. Miller case, first Mrs. Miller case. They wouldn't have answered this question. So I don't think it would have helped. It wouldn't have hindered, but it wouldn't have helped. But my second observation on a written constitution is that surely it's never going to happen. Written constitutions tend to be the product either of revolution, as with the American Constitution, or of decolonisation, as with all the myriad of Commonwealth constitutions. A country which has neither revolution nor decolonisation and doesn't have a written constitution is going to find it a great deal more difficult to get round to making itself a written constitution. And in a country like the United Kingdom, where Parliament is sovereign, it would require Parliament to agree to give up some of its sovereign power. Because the whole point about a written constitution is that it limits powers. And it usually gives power to the judiciary to strike down acts of Parliament. That's a common feature of most of the constitutions with which I'm familiar. So the thought of turkeys and Christmas kind of comes to mind. I cannot really see it happening, nor do I think, whatever anybody may think about us, I do not think that the judiciary of the United Kingdom want the power to strike down acts of the UK Parliament. We're perfectly comfortable with how things are. So those are my two observations in reply to that question.
Thank you very much. Thank you very much. Okay, shall we, there's quite a few in the chat. I'll try and select a couple, and then maybe the people that have raised the questions would like to speak them to actually themselves. So Mohammed Sabluj, would you like to go first? Mohammed's a member of staff in the school. May just take a minute to unmute. You can't unmute. I'll read the question out, and then I'll come to Lord McNally. I think that's a very interesting question. Perhaps you'd like to ask, and Robin Taylor. But I'll read Mohammed's out first. So, were there any restrictions in the jurisdiction of the Supreme Court that justice faced in the judicial review, as opposed to an appeal in this matter? Had an appeal been brought, would that make the decision of the Supreme Court more authoritative? Shall we just take a couple of others and then come back to that one? Robin Taylor, are you able to unmute?
Give me 1 second. I'll see if I can allow people to unmute. So we'll come to Robin Taylor now. Okay, Robin may be able to unmute now.
Can you hear me?
Yes.
Okay. You mentioned that shortly before the failed prorogation, Parliament had passed the European Union Withdrawal No. 2 Act. And I recall that was given royal assent by the simple announcement method in the morning of the 9th of September. Prorogation happened at the end of that day, and the only act given assent in that ceremony was the Parliamentary Buildings Restoration and Renewal Act that had been passed earlier in the sitting. Because of your blank sheet of paper ruling, the parliamentary authorities deemed that the royal assent for that act had been inadvertently annulled, and therefore it had to be given assent again. If the Withdrawal Act had also been assented at prorogation, would that have been similarly annulled? And would the court have been more explicit about the effect of its ruling in that regard? Because I don't know that the court actually said it was trying to annul royal assent. I think that was just a side effect.
Absolutely. Thank you very much. That's an absolutely fascinating question, and actually would require some further research in order to even reach a tentative view on what the right answer is. We were not considering whether the royal assents given at the same time were affected by the blank sheet of paper. Off the top of my head, it sounds quite surprising that they would be. But in any event, it wouldn't have made any difference because we would have to have reached the conclusion that we did. The fact that the withdrawal number 2 bill received royal assent by a different route earlier in the day obviously meant that it wasn't affected, but it wouldn't have mattered that much if it had been affected, because obviously royal assent could have been given when Parliament resumed. So these are technicalities which are of extreme interest to aficionados of parliamentary procedure, but they don't actually affect the principles involved. But thank you for the question. Very intriguing.
Very interesting. And do you have any comment on Mohammed's question? I think about the difference between judicial review and appeal, whether they restrict the way that the court can operate.
Well, of course, we were dealing in both cases with judicial review, and we were hearing an appeal from a judicial review. The way to challenge the validity of governmental action in the absence of a statutory right of appeal from that action is by judicial review. So there's no problem with judicial review. That's the way to do it. There are certain governmental actions for which there is a statutory right of appeal, but prorogation, of course, is not one of them. It didn't really make much difference.
Great, thank you. Okay, so a couple more questions. Lord Tom McNally, and I can't see the full name, but A.G. Latham. So, Lord McNally, can we unmute?
Thank you for that wonderfully uplifting lecture. And I say that as a parliamentarian, not as a lawyer. But you did say in your remarks about the 11 hard-working justices who made the decision, they are not as diverse as I would like. How do we make our judiciary more diverse?
Well, thank you, Lord McNally, for asking that question. I think you asked it of me really quite a long time ago.
Yes. When I was the Minister for Judicial Diversity,
Yes.
And failed absolutely, totally in achieving anything.
Well, I'm not sure that you're correct about that. A great deal of progress has been made during this century, since we have had the Judicial Appointments Commission and an open, transparent, merit-based process for appointing judges. The gender diversity in the judiciary has improved very considerably. It's still not as it should be. Still only a quarter roughly in the High Court, Court of Appeal, and it's gone down a bit since I retired, obviously, in the Supreme Court. But nevertheless, that's a big improvement on how it was, and it is continuing to improve. And lower down the judiciary, it's doing very well. Ethnic diversity is much more complex problem because the barriers and obstacles to success in the legal profession are different for different ethnic groups. And so achieving a proper balance is going to, I think, be more difficult, more complicated. And then there are other dimensions of diversity which are equally challenging, one of which is educational socioeconomic background. I could bang on about this for really quite a long time, but I'd like us to be encouraged by the fact that we do now have a system which is committed to trying to make things better. And the good news is that in the tribunals judiciary, the gender and ethnic balance is not far short of what it is in the working age, in the working population of the comparable age group, which is a great achievement. And if it can be done for the tribunals judiciary, it can in due course be done for the courts judiciary. So don't be too downhearted, Lord McNally. You didn't have a silver bullet. There is no silver bullet, but nevertheless, progress is being made.
Thank you. So I think we perhaps got time for two more. And I mentioned, yeah, A.G. Latham, is it? There's a question taking us back to prorogation, and then a very interesting one. to finish on around sovereignty of Parliament from Paul Evans. So can we unmute AG Latham?
Hi, thank you. The requirement that the length of prorogation must be justified by adequate reason sounds rather like a proportionality requirement, in other words. Would you accept that characterization of it? And do you think that this is something which is going to potentially prove to be relevant in other areas of the prerogative, not just the prorogation prerogative?
Well, there are no doubt theses being written as we speak about whether the concept of proportionality is gradually taking over from the concept of irrationality or Wednesbury unreasonableness in the context of judicial review of governmental action generally. Because there are one or two hints in one or two cases that we might be moving in that direction. But we certainly haven't got there yet. And the cases where we have addressed the problem directly, like the Malayan massacre case, the KU case, it was expressly rejected. So I don't think it's going to happen anytime soon. But the point about the case that we had was that we didn't really have to think very hard about what might or might not be a reasonable justification. That's why I raised the question about what if the evidence had been different, because there was very clearly no evidence of any reasonable justification for anything other than a 4 or 5 day prorogation in preparation for the Queen's speech on the 14th of October. So when you've not got anything, you don't have to worry about what might be justification. Somehow I doubt whether the problem's going to arise again. But if it does, of course, my successors will have to wrestle with it.
Thank you. Okay, can we unmute Paul Evans?
Paul should be able to unmute now.
Hello, good evening, Lady Hill. Thank you very much for that. I was provoked by your reference to the Bill of Rights early in your lecture and William and Mary's acceptance of it before they took the throne. And it's about, you talked about the impossibility of a written constitution, or the unlikelihood of a written constitution.
We've lost him.
Yes, faded out there. I think the question was going to go on to, could Parliament repeal the Bill of Rights?
Yes, well, what a very good question. And if Parliament repealed the Bill of Rights, would it actually, nevertheless, retain the concept of the sovereignty of Parliament, which was cemented by the Bill of Rights? Yes, well, it's an absolutely fascinating question, and no doubt many more theses could be written on that. Parliament can, of course, unmake any law. After all, we had the European Communities Act, which we thought had changed the landscape indefinitely. And it did change it very fundamentally, because it gave the courts power to strike down incompatible legislation, even of the UK Parliament. But Parliament gave us that power, and then it took it away. So, in theory, Parliament can unmake any law. If it unmade the Bill of Rights, I think it's a very interesting question as to whether the courts would nevertheless say that the principle that Parliament could make or unmake any law remained extant, because that was the result of the revolutionary settlement, and it was a revolutionary settlement in 1688. Again, that's another nice one for my successors. But I don't think you're going to engineer the. I don't think you're going to have it happen. So maybe they won't have to decide it.
Okay, great. Well, there's many more questions, but I think we're getting We're running out of time. So, and you've been very generous with your time with us this evening. So thank you very much for that. I think we must wrap up the questions there. On behalf of Royal Holloway, I'd like to extend our thanks to Lady Hale for a fascinating lecture and generosity in answering our questions. Students, colleagues and friends, thank you all for coming to the 2021 Magna Carta lecture. A round of applause is very difficult online, but I know you'll all want to join me in saying thank you once again to Lady Hale. Okay, so thank you very much and good night.